Timber Creek was proclaimed as a town in 1975. It is located in a remote area of the Northern Territory, approximately 600 kilometres south of Darwin. It sits on the banks of the Victoria River and is known for its scenic escarpments and its baobab trees. In the 2016 census, the population of Timber Creek was 249, of whom 2/3 are Indigenous. During the 1980s and 1990s, the Northern Territory government built public works and infrastructure in Timber Creek, including roads, a school, and water infrastructure. The claim group representing the interests of the Ngunnawal and Nungali peoples became native title holders in 2006 for some parts of their town, but not others. The claim group asserted that the infrastructure caused irreparable damage and disconnection with their spiritual land, as well as where their women collected berries had now become weeds, and that the public works disrupted or damaged their dreaming sites. The acts gave rise to the claims group claim for compensation for economic loss of the native title rights and compensation for loss of diminution of connection or traditional attachment to land. The claim was first taken to the Federal Court of Australia in the Northern Territory, where the judge found that the Northern Territory government was responsible for 53 acts that either impaired or extinguished the claim group's native title rights and interests, giving rise to the entitlement to compensation under Section 51 of the Act. The judge in the Federal Court found that the claim group was entitled to compensation for economic loss at 80% of the unencumbered freehold value of the affected land, for interest and for non-economic cultural loss. The decision of the Federal Court was appealed on the basis that the assessment of compensation was incorrect. The primary judge's assessment of economic loss was varied by the full Federal Court, reducing the percentage value of the unencumbered, freehold affected land from 80% to 65%. Otherwise, the full court affirmed the decision of interest and cultural loss. By grants of special leave, appeals were made to the High Court by the Northern Territory and the Commonwealth Government, arguing that the claims were overvalued and the economic loss should not be worth more than 50%. Although the claim group argued that the loss of their rights was worth the entire 100% freehold value of the land.
Going to court makes my old man, who's probably sitting in heaven right now looking down on us, who's smiling right now that we got this far.
The High Court held that the claim group was entitled to compensation for economic loss at no more than 50% of the affected land, for interest and for cultural loss. As the claim group held non-exclusive rights to fish, hunt and to practice their law and culture, but not the right to exclude all people from the land given the nature of these rights, the High Court held that the compensation should be no more than 50% of the freehold value of the land. The High Court took into account the claim group's connection with the land, the effects of when the country is harmed under their laws and customs, and the effects of the compensable acts. The High Court found that the claims group's spiritual connection with their land was unique, deep, and broad, and the effect of the acts included dispossession, ongoing hurt feelings, obstructing access to hunting grounds, damage to significant cultural sites, and interfering the claim group's ability to practice traditions and customs.
When you see damages happen to your land, you feel your tummy, you're hurt, like you're emotionally hurt inside, but you don't show it on the outside, but it's hurting you in the inside.
It breaks the heart of the old people to see these things happening. And it breaks even their heart even more that there is no communication between Indigenous and the non-Indigenous people.
The case is the first time that compensation provisions under the Act have been examined by a court, setting an important precedent for others who have lost their land. It also enables all participants in future claims, including government or private sector proponents, to be in a strong position to negotiate in good faith to come to a fair and just compensation. Using the precedent of calculating potential compensation from Timber Creek, any claims will be judged on their own merits and must meet the conditions of the Native Title Amendment Act, showing continuation of connection with the land in more than a superficial way, as was the challenge for the Yorta Yorta peoples in Members of the Yorta Yorta Aboriginal Community versus Victoria. The Timber Creek decision is a conservative judgment and will not lead to further legislative changes in native title issues. The High Court decision highlights that the vast bulk of Indigenous dispossession and the concomitant and often underappreciated intergenerational impacts remain beyond the remit of compensation law. Over 20 years after the Mabo and Wick decisions, the High Court has confirmed that compensation is appropriate for the extinguishment and displacement of Indigenous Australians. It not only recognises the traditional society that has continued since colonisation, but is finally valuing their customs and traditional communities. It is a positive step for the unity of our nation. The first decision on land rights was the matter of Milarepa versus Nabalco in the Gove land rights case. It was held in this case that native title was not part of Australian law. What the Gove case did recognise was that Indigenous people have a different relationship with the land, using it for shelter and food resources. The Gove case started the ball rolling for native title rights without actually giving land rights to the Indigenous peoples. It wasn't until the decision in Mabo versus Queensland No. 2 that the High Court provided Indigenous claimants with native title. It recognised Indigenous peoples as citizens with entitled rights to ancestral land. This small part of the Murray Islands, home to the Meriam people in the Torres Strait Islands, created a huge step in legal precedence for native title rights.
Came to me through my grandmother and her father. My grandmother was Akazi and her father Gasu, who owned this land initially. And this is the boundary line here. These sort of things that can be seen all over this island. Other families have constructed these things, not just lately, but over many years.
It was only 4 years later that the Wick case built upon the determination of Mabo, where it was determined that native title can coexist with pastoral interests in the land. However, disappointingly, in the event of a disagreement, the decision in Wick determined that the pastoral leaseholder held the strongest interest and security in that land. Following the Mabo decision, the Native Title Act was enacted, and later, after the Wick case, the Native Title Amendment Act. To claim native title rights, the Act, at Part 15, suggested that claimants must show continuing and meaningful connections to the land to ensure native title has not been extinguished. The case of Yorta Yorta went before the Federal Court in Victoria and was appealed to the High Court, where it was held that the peoples of Yorta Yorta were unable to meet this section of the Act. It seems to be a situation of Indigenous peoples being in an Australian court and tried under non-Indigenous customs while attempting to explain Indigenous traditions. It can make it challenging to prove the existence and enjoyment of the land has not been extinguished. Each of these natal title precedent decisions have helped develop the law in recognising the Indigenous connectedness to traditional lands and arriving at fair compensation methods for disassociation from the land, as shown in Timber Creek.